All right, hello and welcome to this webinar on new HR laws during the coronavirus response. My name is John Keimig, and I am the director of the Family Business Center here at the University of St. Thomas. I'm joined by my colleague in the Schultz School of Entrepreneurship, Beth Bagley, who will be assisting with the technical side of this event and stepping in if needed. These webinars are a joint effort of the University of St. Thomas Schultz School of Entrepreneurship, Family Business Center, and Small Business Development Center. This is the second webinar in a series we're creating to bring you up-to-date information to help you and your companies navigate business in this new uncertain time of the coronavirus. Our first was last week on disaster funding. Before we begin, we are recording this webinar and we'll post it on a website our team has created to be a hub of resources for your business. We will send that link out in future emails. And now a quick orientation to the Zoom webinar. All attendees are muted upon entry. However, your participation is really important. We therefore invite you to click on the Q&A button at the bottom of your screen to post questions or add a comment. Please wait until the end of our presentation to ask any questions, as many of the questions that were posed on our last webinar were answered by the presenter as the event went on. I will compile questions to ask the presenters at the conclusion of their presentation. With more than 240 people registered for this webinar, we won't be able to go through individual company-specific issues during the event, but we will give you contact information at the end to connect with our presenters who can help. Now I'm going to introduce Ron Linneman from the WA Group. Ron?
Great. Thanks, John. Good afternoon, everyone. My name is Ron Linneman, and I have my colleague Amy Strike on this call as well. As advisors to many employers, John asked that we schedule this webinar to provide some clarification during these crazy times. Amy and I both work for a WA Group. We're a local 100% employee-owned risk management firm. In addition to the virus itself, COVID-19 has created many more risks to employers and employees than we've ever seen before. So we're helping guiding employers through questions like insurance guidance. Next slide. So questions would be, how does my health insurance coverage cover COVID-19? Will my business interruption policy provide coverage during this time? Next slide. Risk management and safety. What measures do I need to put in place to help prevent an outbreak in my company? Next slide. Compliance and legislation. So questions like, do I have to follow the Families First Coronavirus Response Act? Where can I get the posters I'm required to hang up? Next slide. HR support. Can I take employee temperatures? When can I send employees home if they are showing symptoms? And then the last one is communication and marketing. Communication is extremely important during this time, and we feel obligated to provide continuous up-to-date information to employers, which is why we have asked one of our partners to help answer some of these questions today. And with that, I'll turn it over to Kate at Thrive Law and Consulting.
Hi, everybody. My name is Kate Bischoff. I am a management side employment attorney, so I suffer from law degree. Please don't hold that against me. I got my HR street cred working for the U.S. Department of State as the Human Resources Officer for Consulate General Jerusalem and then the U.S. Embassy in Zambia. I grew up in a family business. My family has an electrical contracting firm in St. Cloud, Minnesota, so I have a love for the family business. What I do now as a solopreneur is I do a lot of training for companies. I work on a lot of policies and random questions like, can I fire this guy, please, Kate? And then I also do investigations. So a client will get an allegation of harassment, so I'll come in and do an investigation and make recommendations. Throughout today's presentation, I'm going to go through very quickly the Families First Coronavirus Response Act and a little bit of the Paycheck Protection Act because those two are a little bit intertwined. As John mentioned at the beginning, if you have questions, please put them in the Q&A section, and then we'll try to get to as many questions as we can. I've done this webinar a couple of times, so I'm going to try to give you as thorough information that we have. The reason why this webinar is date and time stamped is because we are getting a lot of information from the Department of Labor at a fast and furious rate. In fact, we even got guidance from them on a Saturday. We expect that the DOL will issue some new regulations very soon, and so some of this information may change depending on what that guidance says. So this is how a lot of us are feeling right now. We're frantic. Things are coming at us at great speed. We're having to find cash for new benefits. So I'm going to go through what those mean. The first is Families First Coronavirus Response Act. It is for employers with fewer than 500 employees. And this number becomes incredibly important because it also is the threshold for which you may be eligible for loans, particularly from the Paycheck Protection loans. This act expands the Family Medical Leave Act through December of 2020, and it also provides for emergency paid sick leave for 6 different conditions. So this becomes effective tomorrow, April 1st. And so as you're preparing for what this looks like, know that it all becomes effective tomorrow. So starting with, what does fewer than 500 employees mean? The Department of Labor has given us some information on this particular topic. It says if you have 505 employees today, but you're going to do a furlough, so it drops you below that 500 employees, then you become required to provide the leaves that are in this act, okay? So know where you are. I have several clients that are riding that 500 bubble, and they're trying to make decisions as to what they should do, both for loan purposes and also this act purposes. So when you count, we look at all employees, part-time and full-time, and anyone who might be considered a joint employee. So if you use a temporary agency to help provide you help, you count those people into that group. Independent contractors are not included in this count. So if you have multiple subsidiaries, let's say, this is a horrible example for right now, but if you're a restaurant and you have multiple different locations and employees can move back and forth between those locations and there's a common owner, then you count all of those together as one employer. There's a difference for the Paycheck Protection Act that you might be able to count those sites separately for that act for loan purposes, but you count them together for the Families First Coronavirus Act. Okay, so the emergency paid sick leave. Now you've got fewer than 500 employees, and as soon as an employee starts working for you, they are eligible for this paid sick leave. This includes all non-federal private sector employers, and any employee is immediately eligible for up to 80 hours at their regular rate. So it's 2 weeks of paid leave. For part-time employees, it's a prorated amount. So if I work 20 hours per week, then I might be eligible for 20 hours for over that 2-week period, right? Because it's forced to be for 2 weeks. So I get a prorated amount. This is in addition to any current PTO or sick time you've already offered. If you gave people more sick leave prior to April 1, you don't get credit for that. The act becomes effective only on April 1, okay? There are 6 different reasons for why an individual might be eligible for emergency sick leave. And these include the following. They received an isolation or quarantine order related to COVID-19. This does not include stay-at-home orders, okay? If your business has closed or has slowed down because of a shelter in place or the Governor Walz's stay-at-home order, this does not apply because there's nothing for them to take leave away from work. There's no work. So they should be furloughed and be on unemployment. The second reason is that they've been advised by their healthcare provider to self-quarantine. The third, they're experiencing symptoms of COVID-19. Take a look at the CDC website for what those symptoms are, and that they are seeking a diagnosis. This is going to become really important. I'm going to explain why in a bit. These first 3 reasons have a different payout rate than reasons 4 through 6. So let's go through what 4 through 6 are. Caring for a family member who's quarantining or subject to an isolation order. Caring for a son or daughter who can't be in school or daycare due to a COVID-related closure. So all schools right now are closed. So that if somebody needs to provide daycare or childcare for their kid because their kid is at home, the sick leave will come into play. An employee who has experienced a substantially similar conditions to experiences 1 through 5. We don't really know what this catch-all provision actually means, but if it's something that's substantially similar, then emergency sick leave will come into play. So the big deal here is the math, okay? The first for the Coronavirus Response Act is that they get their regular rate of pay. which is calculated by the average over a period of up to 6 months prior to the date of the leave. So if we're looking at leave starting April 1, we look back at their pay through November 1, and then we take the average of what that pay would be. This will include things like commissions, bonuses, etc. It puts a cap on the amount for the reason for the leave. So reasons 1 through 3, meaning the employee's own conditions or the government ordered quarantine or self-quarantine. The employee can get up to their regular rate up to $511 per day or $5,110 over the 2 weeks total, okay? Here's why. The $511 can come as a tax credit from the withholdings you have withheld so far, okay? So the Social Security numbers that you have collected that you're about to pay in your quarterly taxes, you can use that bank of money to fund this leave, okay? Talk to your tax professional about that specifically. For reasons 4 through 6, where they're caring for others or that there's the catch-all provision, an employee can take their regular rate up to $200 a day or $2,000 total. Okay, so for either of these, let's say I make about $600 a day. Okay, I get paid about $300,000 a week, God willing. So that's what I make. You can either pay me the regular rate, which would be more than the $511, or you can pay me just the $511. That $111 difference cannot come from your tax withholdings. You get only the amount, the max at $511 out of the tax withholdings or the tax credit for that. If I make less than $511 per day, let's say I make $300 a day, you pay me my regular rate to $300, and then you save that $211, okay? You don't get to use that out of the tax for some other purpose. You pay my regular rate up to $511, or for if I'm caring for someone, it is up to $200 a day and no more, okay? You may use the tax withholdings you've collected but not yet paid, and really talk with your tax professional about how this is going to work in your bank of dollars. Okay, so now the expanded family medical leave. Again, it's an employer with fewer than 500 employees. The employee who wants to take the leave must have worked for you for at least 30 days, 30 calendar days. They get up to 12 weeks of leave. Now, this is expanded FMLA leave, meaning if they've already taken 6 weeks of FMLA for a different condition, let's say they have cancer, they only get a total of 12 weeks over the year. Okay, so they might have already qualified for the first 6 weeks, but they get an additional 6 weeks under this, and this time it's paid, okay? So the only way you get expanded FMLA is if you're unable to work or telework due to a school or daycare closure. Okay, so let's run through an example. My kid's school is closed. I need to provide them childcare during the day. They can't just roam about my house willy-nilly. So I need to take this expanded FMLA leave. I get $200 a day during that. If I am able to telework while they're at home with me, then I don't get this leave. Okay, so the question is, can the individual telework, work from home, rather than needing to take the time off? This is still going to be able to take the time if, let's say my kid is under the age of 12 and they need constant supervision. If I'm not able to work for that reason, I may be able to take expanded medical leave as well. Okay, so the first 2 weeks of this expanded family medical leave are going to be unpaid. Okay, but there's the emergency paid leave that'll fit in. So if I'm the one who is sick, I get the $511 a day for those first 2 weeks. And then if I need the time because my kid is at home, then I get the $200 a day for the additional 10 weeks. Okay, talk to a tax professional. Now, there is a carve out for specific employers. Employers with fewer than 50 employees in a 75-mile radius, it is unlikely that you're going to be able to be sued under this act. However, the Department of Labor may still do an investigation if you fail to provide this. There are two major exceptions to the rule, which are for healthcare providers and first responders. The definition for a healthcare provider in the Department of Labor's frequently asked questions is massive. It is a massive exception for those who provide healthcare, okay, including those who do assisted home healthcare, okay? The definition of first responder is also massive. This is going to include your firefighters, your police officers, your EMTs. It is also a big group of people. Again, we're expecting regulations shortly to answer a bunch of other questions. Right now, I believe the Department of Labor's FAQs, which is linked here in the PowerPoint, has 59 different questions and answers to it. So it's very detailed, okay? Now, for small employers, there is another exception for you. And the other exception is if you provide this leave, if the viability of your business means that you will need to close, then you are not required to provide this leave. And there are 3 different conditions for which the Department of Labor has said that this is okay. The first is if providing the leave would require spending that would exceed your available revenues and mean you'd have to close. Okay, so you just can't afford it. There's not enough money coming in. If you paid it out, it would mean you would require bankruptcy. Okay. The second is if providing the leave would result in substantial risk to the finances of the business, financial health, operation, capabilities of the business because of the specialized skills and knowledge or responsibilities of this individual employee. This is like the key employee exception to the regular FMLA. This particular employee is so necessary, so integral to our business, we can't let this person take time off. Now, let's think about that for a second. If this employee is experiencing symptoms of COVID-19, do I want to say to them, you can't take leave? The answer better be, oh, hell no. Because I don't want that employee in my office because they're sick. I probably also don't want this employee working from home. So think very carefully if you want to use this exception. The third exception is if providing the leave would mean that, would mean that there is not sufficient workers who are able, willing, and qualified and who will be available at the time or place needed to perform the labor or services provided by the employee or employees requesting paid sick leave or expanded FMLA leave, and these labor and services are needed for the small business to operate at a minimum capacity. Let's say you run a convenience store. You have 7 employees who run a rotating shift to keep the store open. If an employee needs to take time off for any of the 6 reasons under the emergency paid or the expanded FMLA to care for their children, and if they took if 2 of them or 3 of them took too much time, so it means that the convenience store couldn't even be open, you can deny the leave under this exception. But again, I want you to think long and hard about this. If the employee is experiencing symptoms or is self-quarantining, do you want to say you can't take time off? No, because you don't want to expose your customers to that particular individual. You can say we're not going to pay for that, but you can say we still don't want you to come in, if that makes sense. Okay. For my clients, what I have been saying to them, and I'm not providing anyone specific legal advice, is if the second or third thing here is for childcare reasons, you can deny the payment part of that leave. I feel comfortable saying because they're not the ones who are actually sick, or they're not the people who are exposed to someone who might actually be sick. But for if they're actually sick, let's send them out. Let's pay them for this because it makes more sense and it's the right thing to do. Relying on these 2 things is going to be very, very tricky. Okay. Okay, so let's go through a scenario. James is in accounting. His live-in girlfriend is sick and has been told to self-isolate and self-quarantine. Okay, so he's going to too. As of tomorrow, the questions you are going to ask James are, has he called his healthcare provider to determine whether or not he should self-quarantine? Okay, we want him to call the healthcare provider so that he clearly falls into the second category of the emergency paid sick leave. If yes, the employer says or the healthcare provider says he should, then he gets emergency paid sick leave at up to $511 per day. When he calls you, you're going to ask him if he's talked to his healthcare provider. If he said no, you're going to say, go call your healthcare provider. He does not need to be seen by a healthcare provider. Just a phone call is going to be necessary. What you're going to do is then you're going to write down, James called He called back. His healthcare provider, let's say it's the Richfield Allina Clinic, told him to self-quarantine as well. That's what you're going to write down as your documentation. You can send James an email summarizing that conversation, including the clinic name, and that will be sufficient documentation for the tax credit at this time. We have not seen what the IRS is going to say for forms, but that's how you should document it from an HR perspective. Okay? So, a common question, what if we just lay James off instead of letting him self-quarantine and taking this leave? If you are going to lay him off and it's just him, okay, there is an argument that you are trying to avoid payment of the emergency paid sick time, the expanded FMLA, or public policy, and you could get sued. Okay, you could get sued. If he's part of a larger furlough that his individual condition was not taken into place, then you're probably okay. Both the emergency paid sick leave and the expanded FMLA leave have retaliation triggers in there, so that if you are trying to avoid that payment, then you could be both investigated by the Department of Labor and also sued. Big no-no. Okay, so here's another common scenario. Michaela tells you that she has tested positive for COVID-19. In your position, the question is, do I tell the other employees that Michaela has interacted with? The answer is no. The Equal Employment Opportunity Commission, the EEOC, which oversees the ADA, will tell you that her condition of being positive for COVID-19 is still confidential medical information that you cannot share with individuals outside of, besides her, okay? So you don't necessarily have a moral obligation to them. I'm not going to be dictating what your morals are, but hopefully you've put a whole bunch of strategies in place around physical distancing so that the exposure that she might have given to other people has been very limited, including splitting shifts, working every other day, working from home, having increased hygiene, and telling people to stay home if they're sick. The EEOC is very clear. You can tell people to stay home if you are sick. One question that's come up over and over is, do I have to tell OSHA about this potential infectious disease? And the answer I have for you is nope. Please don't call OSHA. If the numbers of individuals who are likely to get COVID-19 are true, OSHA is never going to have enough time to do investigations, is never going to have enough time to actually deal with these situations or produce fines. So ignore OSHA on COVID-19 issues. Okay. Next, so when we're looking at COVID-19 and we're looking at the economic conditions that are coming out of them, there's often the question of, should I furlough folks or should I lay them off? Okay, so these are two different options. A furlough is when I cut people's hours, including cutting hours to zero, meaning that I'm temporarily laying them off with the intent to bring them back at another time. Okay, I intend people to come back to work for me. Okay, may an employee, hold on, I just want to double check one thing. You are doing this temporarily. We expect that once this situation is over, inshallah, that this individual will be able to come back to work. Okay, you can keep the employee on healthcare insurance and other benefits. You can pay the cost of their COBRA for this, because if they've dropped below the hours, it's going to be a COBRA triggering event. And there is no need to pay out accrued but unpaid overtime, because I intend to bring them back. Once someone is furloughed, if you decide, well, we just can't bring them back, then you'll pay out the unpaid PTO that they have accrued over time. A layoff is different. A layoff looks like I am permanently laying you off. I don't know if I'll ever be able to bring you back. Again, you may keep the employee on your health insurance or other kinds of benefits through COBRA by making those payments, but you are going to need to pay any accrued but unearned or earned but unpaid PTO they have accumulated over that time, if that is within your policy and your practice. Okay, so there's these two issues. The beautiful thing of both of them is that everyone is eligible for unemployment, regardless if it's a furlough or if it's a layoff. Now, for a lot of my clients, we're looking at making some really difficult decisions. Normally, if we would be doing a layoff, we'd be looking at paying a severance. and trying to get a release of claims in the form of an agreement. If we do that, there is a 45-day consideration period and then a 15-day rescission period at the end. Meaning in normal practice, we might not pay that individual for up to 60 days because we want to let that rescission period lapse. We would also have to do what's called the Older Worker Benefit Protection Act notices, which is where we do the decision tree of here are all the individuals who were in this business unit, here's how old they are, and here's whether or not they were determined to be part of this layoff. Those notices take time to prepare. They can be very difficult to prepare. And with the notice and with the severance agreement, there's a lot of time for people not having cash. So you may want to instead take any money that you would normally put into a severance payment and put it at COBRA. Throw it at COBRA because we want people to have as much health insurance and healthcare as we can without causing dramatic financial ruin. So instead of doing the severance, which we don't need the release of claims as much right now. We don't think that, there's a huge economic downturn. We don't assume that people are going to sue us for discrimination or those kinds of claims. So it would be better to get them on health insurance much faster and keep them there and get them on unemployment, because Minnesota expanded its unemployment, meaning that you are eligible as of day one when you apply for unemployment. So we want to get people there as fast as we possibly can. Okay. So let's talk a little bit about the SBA loans. So in the second big coronavirus piece of legislation called the CARES Act, there was a provision for paycheck protection, which offers up to $10 million loans for small businesses. And the definition of small business here is 500 or fewer employees, provided you meet the following conditions. One, you do not reduce payroll upon receiving the funds. So at the time, it's going to depend on your bank, I believe, if whether at the time you apply or at the time you get the funds, you have less than 500 employees. So again, if you're right in that 500 employee bubble, you want to be firm as to which category you fall into. Because if you are 500 and fewer, you're paying out this emergency sick leave and the expanded FMLA, but you're eligible for up to $10 million in loans. Big thing to consider. The loans themselves may be forgivable if all employees are kept on payroll for at least 8 weeks. So for the next 8 weeks, if they're going to be able, you have enough money or cash sitting around to pay them, and you get these loans, if you keep them on for 8 weeks, the entire loan may be forgivable. And it can be used for things like payroll, benefits, mortgage interest, rent, utilities, etc. Okay, so the first call y'all should be making is to your banker and accountant. There is only $349 billion available for these loans. I know it sounds ridiculous for someone to be saying there's only $349 billion. However, at $10 million a piece, that money could go very fast. So you want to talk to your banker, you want to talk to your accountant, you want to talk to your tax professional. Try to do all of that this week. If you need help creating the policies and creating the forms that you might need, because as of tomorrow, you are required to send out the Department of Labor notices for the Families First Coronavirus Response Act. Those are available on the Work Posters website for the Department of Labor, that you can grab that. There is a significant typo on the form. It says that somebody is eligible for the $200 a day up to $12,000, which is true if you combine both the paid leave and the expanded FMLA. However, under where it's listed, it should only be $10,000. So you can ignore that. Sending the poster and putting it up on your intranet site will be sufficient. Emailing it will be fine. You don't necessarily need to post it, because hopefully a lot of your employees are not going to a physical location at this point in time. But emailing the poster out will be enough as well. If you'd like the one pager that can act as a policy, please feel free to email me as well. Okay? Other considerations coming out of this coronavirus is discrimination and harassment. Asian Americans in particular have been reporting a significant spike in harassment. Remember, your obligations as a business owner is to continue to provide a workplace free of harassment. If an employee complains of harassment, you must take action at that point in time. Do not wait, even if employees are working from home. The availability of technology to enhance and spread harassment is significant. Also, and when we went through the expanded FMLA is only applies if an individual has kids who need to be, and they need to be at home for daycare or school closure issues. This means it's going to be really enticing to say, if I have to lay off employees, I'm going to lay those employees off first because they have the significant cost attached to them. Not only could that be a retaliation under the expanded FMLA, but it also could be familial status discrimination. In Minnesota, familial status is a protected class, meaning whether or not I have kids is protected class. You cannot use that as a factor in any employment decisions that you make regarding me. If the temptation is that you should then furlough me first, then it's likely to result in discrimination within 1 year statute of limitations under the Minnesota Human Rights Act. So resist that temptation. You go through, if you need to do a furlough, go through what you want those criteria to be right now. Is it going to be based on performance? Is it going to be based on business necessity? Is it going to be based on seniority? Come up with the criteria for what that furlough will look like so that familial status is not going to be a part of that. And remember, you still have tax advantages for giving that particular form of leave. So it's kind of a wash overall, even though there is going to be that temptation to use familial status. Okay, so be mindful of that. Let's talk about documentation. Now, I'm going to get on my soapbox here. I understand this, but do not ask for documentation from a healthcare provider. Do not be that employer who says, hey, doc, I need you to stop treating that COVID-19 patient so you can fill out a form for me. Don't be that person, okay? So again, the documentation looks like you're going to talk to the employee over the phone. Hopefully you're not going to be within 6 feet of them. Okay, you're going to send an email to yourself regarding the conversation because the email is going to be date and time stamped. I'm going to be able to trace it back and be able to find it. Contrary to November 2016, it's very easy to find emails. Okay, so we're going to write the reason for the leave. If it is the paid sick leave, which one of the 6 reasons does that fall under? We're going to have the name of the healthcare provider. The name of the clinic is going to be fine. The employee might not know which nurse or which doctor they actually spoke to. We're going to say how much we're going to calculate. So if this is going to be your regular rate at $300 a day, or if this is going to be the maximum amount at $511 or $200, we're going to put that in the email as well. And then you can use your old friend Excel to track these leaves because we are going to need to share this information with the IRS and or the Department of Labor if they ever ask. The IRS so that we can prove why we took the withholdings and to get the tax credit. We can sort documentation out later if absolutely necessary, okay? We don't need to have it right then and there in our hands, okay? Next, the unemployment. So because Minnesota has expanded unemployment coverage for any COVID-19 related furloughs or terminations, employees are eligible for unemployment as of day 1. So if you do need to do a furlough, in that letter notifying them of the furlough, hopefully you've had a conversation, but you're sending a letter to confirm. You're going to say, this is COVID related. We want you to apply for unemployment. And you put the link in the letter right then and there, if it's an email, if whatever, so that they have easy access to applying for unemployment. The letter should say economic conditions related to COVID-19, so that gets them an automatic trigger. Mr. Grove of Deed has said he does not anticipate raising taxes or raising your experience rating if you furlough people right now. So encourage people to get on unemployment. Congress has massively increased the benefits under the CARES Act, that second, or otherwise known as the stimulus bill that came out of this. And we should tell folks that unemployment is not a bad thing. It is a safety net that is there designed to help ease the blow of these kinds of situations, okay? And so while the max rate is $740 now, we believe that that max rate is going to be increasing so people can pay things like rent, they can pay things like food and and prescriptions. We want them to be getting those kinds of things. If you are from a different state than Minnesota, check with your own individual state's unemployment, because again, unemployment has been expanded nationwide. So I don't know the maximum amounts for other states, but check with your individual state. Okay. So let's talk a second about shelter-in-place orders. Minnesota has a stay-at-home order, and there is a debate whether that particular order qualifies as for the first reason for the emergency sick leave, or paid sick leave, which is you've been ordered under a quarantine order. Okay, some attorneys are saying no, that would not trigger the emergency paid sick leave. Some are saying yes. Here's my position. I believe a statewide order would trigger the emergency pay leave for any organization that is still in business. And the reason I say still in business is if you have furlough people, if nobody is working right now, there's nothing for them to take a leave from because they're not working. They should be on unemployment. You can't get both unemployment and these paid leaves, okay? So if you are essential or non-essential, that's gonna be helped determine. If you're essential, which is a horrible word because we're all essential, if you're essential, they need the time off for the reasons 1 through 6, or for the childcare, then they get the paid leave. If you are non-essential and you're off because you've closed business, you are eligible for unemployment, not necessarily the same way, okay? So let's go through a scenario, okay? April 1, 2020, tomorrow, the governor has ordered a shelter in place or stay at home. The employee has kids under the age of 18 and the business is still operating, okay? If that's the case, they could get emergency paid sick leave if they are caring for themselves, if they themselves are sick, okay? Which means they get the regular pay up to $511 a day for the reasons 1 through 3, and then $200 for the day after, okay, for reasons 4 through 6. And then the expanded FMLA could go into effect for them. So if they have kids under the age of 18 and they're providing childcare, they get 2/3 their regular rate up to $200 a day for a total of $10,000. Add those two things together, if it's all childcare related, that's a max of $10,000. If it's they themselves are sick with COVID related symptoms, and then they need time off for their care, the max that employee could receive is $15,000, $15,110, okay? Now, let's do it for an employee who has no kids and the business is still operating. Emergency paid sick leave goes into effect if the employee has reasons 1 through 3, they're sick or they're self-quarantining, okay? They get up to $500 and $11 per day. If it's reasons 4 through 6, okay? They don't have kids, so they might be caring for someone who's in self-quarantining, meaning they get $200 for that time. Expanded FMLA is not going to apply. They're going to get the total of up to 80 hours and no additional time off. Okay, see the temptation for wanting to make sure you have employees who don't have kids? Again, discriminatory under the Minnesota Human Rights Act. There is no exception for that here. And the retaliation provision might come into place. Okay, let's do this one. The governor has ordered a shelter in place. The employee has kids under the age of 18, but the business has decided to close for the time being. Okay, we are not an essential business by the governor's orders. We're going to close for the time being. This means that every employee should be furloughed, and that because they are furloughed, they should be receiving unemployment. Okay, there's no employment for them to take leave from, so there's no need to pay them these forms of leave. Okay, because they're not taking a leave, they're been furloughed. Okay, so think of it that way. Can we have an employee on unemployment? Or are we still operating? We need this employee to come back from a leave. Then we provide those kinds of leaves. Okay. Now, before we get into questions, I understand that this is an incredibly difficult time. Your folks are scared. They're scared not only of the illness, but they're also scared of what's going to happen with their job. Okay. So take a moment to think about what your plan is going forward. Take a breath. Take care of yourselves, because we also don't want you all to get sick too. So take a breath. We're going to be able to get through this. Okay, let's go with some questions, my friends. What do you got?
All right, this is John hopping back in. So please ask your questions at this point, and I will relay them to our panelists. Thank you, Kate. That was very informative, very informative. Just first one, please confirm PTO given prior to April 1st is independent of the 80 hours of emergency paid sick leave. An additional 80 hours must be given to employees on 4/1 tomorrow.
Yes, provided that they meet the criteria for the emergency paid leave and or the expanded FMLA. Yes, this is additional. If you gave more time, so let's say you learned March 10th and you wanted to give more people more time, that doesn't count. You don't get a credit for it.
Do we have to inform our staff about the leaves available?
Yes, you do. As of tomorrow, you should have posters up, or you should be sending them out via email or posting on your intranet site. Again, the posters are available on the DOL website under workplace posters. Look for Families First Coronavirus.
How long can I furlough someone for? Is there a max length when you have to rehire them?
No, there's no max length of when you need to rehire them. We know that unemployment has been expanded from 26 weeks to 39. So technically, you probably haven't furloughed for that entire period. But I want you to be in contact with your employees while they've been furloughed. Even if you don't know when you're going to be able to open back up, if you keep a connection with them over this period of time, not asking them to do work, but keeping a connection with them, they're going to be more likely to be your champions when you come back. You want to keep that relationship so that when and if you are able to open, they're right there willing to come back to you. So work on those kinds of connections while you're furloughed.
For the payroll protection, when does the 8 weeks start, or is it based off the date of a loan origination?
I would talk to your bank as to how they count that 8 weeks and what they believe the SBA will do for forgiveness. I am not a person who is well versed in what those triggers are going to be, and so I would talk to your bank and they will have more information.
If an employee has told us in an email that his wife is work from home and he does not need to care for his kids, he would not later be eligible for this expanded FMLA, correct?
He could be if he now needs to provide care. He could be. I don't write it off entirely, but it could be that he doesn't need to.
If we're under 50 employees, are we exempt?
No, you're not exempt. You might not be able to be sued, and you could use those 3 different conditions for why you might not be necessary to give it, meaning that you're not going to be viable if you have to provide these benefits. But the Department of Labor could still do an investigation and still try to enforce the act with you. They have told us that they intend to give a 30-day kind of grace period of non-enforcement. So the month of April is going to be free, really, as long as you're trying to do your best to comply, but they can still enforce it. You just can't be sued individually for it.
We made significant pay cuts effective this week to stay in business. How would the Paycheck Protection calculate the rate of pay? Do we need to revert back to original rate of pay to realize the benefits?
That I don't know. Talk with your banker and your accountant.
If I furlough any or lay off any employees, do I still qualify for the CARES Act?
It depends on what your employee count is and when that count is going to start. So if you did furloughs before now, let's say you laid off 10 people and you think you can run at your current level for the next 8 weeks, the count is likely to be what you have at the time you apply or when the funds are delivered. And so use that time. I wouldn't explain that you had people beforehand. And during the period of this 8 weeks or during the period of the loan, you are going to have to be a great employer. You are going to have to provide these paid leaves. You're going to have to make sure that you are not engaging in any kind of Fair Labor Standards Act violations, that you are paying overtime, that you're being on top of all of those things, because the loans themselves are forgivable provided you've been a good employer. If you're a bad employer, you've been cutting corners, you've been refusing to pay overtime, etc., there's a chance that these loans will not be forgiven. The interest rates are going to be up to 4%, but still you don't want to have to repay these if you can be a better employer.
Can we make our employees use their PTO first?
You might, but If I were you, I would want to receive the tax credit first before paying out of my cash for the PTO. There is a provision in the law that says that you cannot demand that someone use the paid sick leave first, but there's no damages to that. And so if I was an employer, I would want to reap the benefit of the tax credit first.
If an employee quits because of a concern over COVID-19, would they be eligible for unemployment?
No. If an employee is super scared about coming to work because of COVID-19, my recommendation would be to furlough them and tell them that you're furloughing them so that they're eligible for unemployment. If they quit for this reason, then they might not be eligible for unemployment. And I would much rather have my people on unemployment than them being out in the wild with no money to pay for groceries.
Any exception for poster notifications for employers based on size of company?
Not that I'm aware of, but sending a quick email to folks with the link to the poster is going to be the wisest and the least risky.
For unemployment, is the $600 extra for only 4 months, and/or does it expire at a certain date?
That I don't know. I would look at Deed's website for that kind of information.
Is contracting COVID eligible for short-term disability?
It may be, but it's going to depend on your provider. If you are self-insured for short-term disability, the only kind of STD you want, you may be able to change your policy to provide short-term disability in place of these kinds of paid leaves. However, if you have outsourced to a third-party short-term disability provider, it is unlikely that those are going to cover. Do you agree, Ron?
I would think that especially during these times, provisions are going to be changed in a fully insured short-term disability policy. And my guess is that the claim would get paid out.
But for a third-party provider?
Yep.
Yes. Okay. It could be, but in my experience with third-party providers, they are trying to hold on to their cash as much as possible. And so, and also think of the documentation you need for a third-party provider for short-term disability. So that's going to be challenging.
Is the $600 federal top up for unemployment benefits scaled at all based on state benefits?
I believe so. It's still on income levels as well.
If an employee tests positive and reports to the employer, can the employer ask that employee for permission to disclose this status at the workplace to take appropriate action?
I wouldn't necessarily request that kind of permission because, again, the EEOC looks at this as confidential medical information, and a violation of the ADA's provision on confidential health information carries with it significant weight. So I wouldn't ask for permission to share this information. If the employee says, go tell Susie that I've got COVID so that she goes and washes her hands, well, then maybe that's fine, but I wouldn't be seeking that kind of permission.
Are these loans based on any need? If so, what criteria is used?
Don't know. Talk to your bank.
If somebody tests positive, do we need to close operations, and when can we reopen?
You may choose to close if someone has tested positive, particularly if you're working in very close quarters. That might be a wise decision to make. And when you reopen is really up to you. Look at the CDC's website about things like how long the virus can live on surfaces. I believe it's up to 3 days, and some depending on the surface. And so you may want to choose to close for a few days while the virus dies on your surfaces and then do a thorough cleaning after that. It's really up to you. There's no legal guidance here on what that will mean or no statutory provisions of what that to mean. It's up to you and up to your discretion. Know that if you do close, your employees are then eligible for unemployment.
Regarding the 500 employee count, is that as of April 1st or calculated over a period of time? And are employers over 500 eligible for the tax credit?
Under the Families for Coronavirus Response Act, this paid leave and the expanded FMLA leave, if you're over 500, you're not required to provide these leaves in the first place. The count for this Coronavirus Response Act depends on the day the employee requests the leave. So if I have 510 employees on April 1, but then I do a furlough, so now I'm down to 475. If Jimmy asks for the leave on April 1, he's not eligible for the paid leaves. But once I'm under 500, he is eligible for those paid leaves. So watch your employee count very closely. The 500 for the loans will be dependent on if it's the date of your application or the date the funds arrive, and that you need to talk to your bank as to that amount.
To reiterate on the FMLA, if an employee just returned from 12 weeks of FMLA, maybe due to a pregnancy, would they be eligible for another 12 weeks with the expanded FMLA? And would you calculate pay based only on working out of 3 of the last 6 months?
I would calculate the rate based upon what they normally earn for that particular situation. So let's say I've got a woman who gave birth December 1. She's been out December, January, and February, and she worked the month of March. So I'm going to be very risk adverse in this particular situation. So if she was sick herself, I would give her her regular rate for the paid sick leave. For the expanded FMLA, if I'm using a calendar year to count FMLA, she has only used 8 or 9 weeks, depending on how you count January and February. So she gets additional 3 weeks of expanded FMLA that can run concurrently with the expanded FMLA or the expanded emergency paid sick leave. So remember, the emergency paid sick leave covers the first 2 weeks of the expanded FMLA. So she'll get 2 weeks of paid time off, and then she'll get 1 week of the expanded FMLA if that's what she needs it for. Okay, so she only gets 3 more weeks under this than whatever she has for PTO, or it's an unpaid going forward. That's how the leave would actually work. If you have a rolling calendar period, then if she's already used her 12 weeks, then she's not eligible for the expanded FMLA. She will get the paid sick leave, but not the FMLA.
We have 2 states we have companies in. Do we count the employee total combined or separated to apply for this?
You would look at how many employees do you have overall. Do they share common ownership, common management, if they're like just 2 different sites, or if they're 2 different businesses? You still look at whether or not they're integrated enough so that if they are, then they're one organization, and that might push you over the 500 number. For the loans, depending on the industry that you're in, you might be able to use them separately as 2 separate pieces. But for the Families First Coronavirus, you might have to combine them.
We've halted operations due to the Stay-at-Home Act. It seems counterintuitive to apply for the CARES Act and call them into work. Do I have to reopen business and create work activities if I receive the funds? Funds would be helpful to help pay for lease payments and other expenses to keep the business open, not necessarily payroll.
I believe you have to keep people on payroll. That is one of the requirements to have the loan be forgivable. So my guess is talk to your banker for more information.
One of our employees has wanted the payout under the Extended Family Leave Act for this week already. What do we do until this kicks in tomorrow?
You can choose to have them use their PTO. You can make it unpaid. You can do all variety of things. But as of tomorrow, April 1, they are eligible for it, and they should receive it if they are otherwise eligible.
Okay, a couple more questions. If the Secretary of Labor issues an exemption for the 80 hours of emergency paid sick leave for employers with less than 50 employees, but that employer pays the 80 hours after April 1, would they then not qualify for the tax credit? Or can any employer under 50 choose to provide the 80 hours under the emergency paid sick leave?
Any employer can offer the emergency paid sick leave and use the tax credit. If you want the exceptions, like your healthcare provider or first responder, then don't apply the exception. If you are a small business and it's going to not make you viable, then that's the only reason why you're going to be asking for an exception for the DOL from the Department of Labor if you need it. And so if you paid it, then it didn't make you not viable. So those 2 things aren't necessarily consistent. Do not send information to the DOL asking for an exemption. They are not going to do it on an individual employer by employer basis. The only way they're going to be applying it is if they get a complaint and you didn't provide it, and now you want forgiveness. You're not going to be asking for permission. You're only going to be asking for forgiveness in this scenario.
Do you have any information about the taxes employers are supposed to submit for the paid sick leave or the FMLA?
It should be regular wages, how you're treating it for regular wages. So the same kinds of withholdings are going to be true from that perspective. If you want to know how the tax treatment is going to be done, you should talk to your tax preparer.
Last question, please explain if an employer can use 80 hours of paid sick leave for themselves, then also use 80 hours of sick leave for families, or is that double dipping?
That is double dipping. There's only one set of 80 hours. Okay. So if you're going to use it for yourself and you use all 80, there's not another bucket for one of the other 5 reasons.
Great. Can we go to the next slide and have a couple updates as we wrap up this event here? So we've had Kate's information up there. Here is the information for Ron and Amy as well. And we will get this video linked up as soon as possible and get these slides up. Future webinars we are working on right now, but don't have dates and times quite set yet. One is a business owner roundtable where owners are going to be sharing wins, things that are working in their business that we can learn from each other. So the people that are in their businesses doing unique things, and that they can share that those what they've learned, and you can hopefully apply it in your business. If your company has done something that is pretty remarkable in your eyes that others could learn from, please let me know. There's an email there on the screen, and we'll try to get you included in that as well. We're also working on an additional federal and state funding webinar, but as was mentioned with Kate, a lot of this information just keeps coming out really kind of nonstop. And so we're waiting to see from the SBA more details on that before we put a full webinar together that will be really beneficial for you. If you have a need or idea for more topics for us, send us an email. I would once again like to thank the University of St. Thomas Schultz School of Entrepreneurship, Small Business Development Center, and Family Business Center for putting this on. The link at the bottom of the screen is where this video and other videos and additional resources will be located. It's link.stthomas.edu/business support series. Yes, that's a lot of S's right in a row there, business support series. And please go there and use the resources that we've provided for you to help your companies at this time. I'd like to thank Kate, Ron, and Amy for being on and for taking the time to do this. We had well over 100 people on this call, so thank you all, and good luck and stay healthy.